Good morning and welcome to the Florida Supreme Court. Before we get started with our cases today, I just wanted to acknowledge this is our first argument since the retirement of our colleague, Justice Ricky Polston, and wanted to thank him for his excellent service to the court, his companionship, friendship. He is a great guy, and we all are going to miss working with him. And just wanted to acknowledge his great service to the state and to the people of our state. We're going to hear our first two cases today and then take a brief break and then hear the last two. The first case today is number 22-1084, In Re Amendments to Florida Rule of Appellate Procedure 9.130.
Good morning, Chief Justice, Justices. May it please the Court. Aaron Daniel from Kuhl & Associates on behalf of the Florida Bar's Appellate Court Rules Committee. The committee petitions this Court to amend Rule 9.130 to include review of non-final orders that deny motions under Florida Statute Sections 768.295, Subpart 4. The proposal that you have before you today was unanimously passed by the full committee, and I'd like to explain the committee's deliberation process for the court. So this referral emerged from a conflict between the district courts of appeal, initially between the second and the fourth, on whether or not these SLAP being strategic lawsuits against public participation, these anti-SLAP motions, orders on these motions, were reviewable by certiorari. And so the committee received this referral and looked to primarily a case that both of the initial conflict cases cited, the Keck versus Immunizer case from this court, in which this court articulated 4 factors that it would analyze in determining whether to expand non-final jurisdiction. And so that's the guidepost that the committee used. And the first factor, of course, being the nature of the rights involved. Here we have very weighty rights involved, of course, constitutional rights to freedom of speech, as well as substantive rights granted in the statute designed to protect those constitutional rights. So it seems like part of what's going on here involves what you're getting to with understanding what the statute is, what it does, and it seems like the court, there's not a sort of uniform view as to what that is. I know there's some federal courts that have described it as basically just a fee-shifting statute, and think that a lot of the stuff in here is kind of hortatory. I mean, do we need to sort of have a fixed view of how to resolve those issues in order for us to make an informed judgment as to whether to adopt this rule amendment? So 2 responses to that, Your Honor. The first is that at the time that the committee deliberated on this and then voted and then submitted its petition even, there wasn't much of a debate over what the statute was. Both the second and the fourth likened it to immunity from suit. And, that's based on the language of the statute and the rights granted therein. And as Your Honor pointed out, the hortatory language. Subsequently, there was the Lamb decision out of the 3rd DCA that did bring up this issue of, well, maybe it's just the Lamb decision said it's just a fee-shifting statute. Now, that decision was not a decision that concerned reviewability. It was a final appeal determining the burden shifting, whether or not there was burden shifting involved. So a merits issue. But nonetheless, so that was where the committee stood and explains why the committee came out the way it did. At the time, there wasn't much of a debate on this. Now, there appears to be some debate. But in the committee's view, and this is discussed a little bit in our response to the comment from the opposing law firm, even if it's something that is less than a protection from immunity from suit, it is an irreparable harm that the movants experience when they are not allowed immediate review. You cannot get your right to an expeditious resolution, which is the statutory language, back on plenary appeal, you can't get the right.
But really, though, the irreparable harm thing really does seem like it depends on an analogy to the immunity in the sense that we just, in general, as much as nobody likes to be subjected to a ultimately meritless litigation, we don't typically view that as irreparable harm, right?
Correct, Your Honor. And again, the difference here, this is kind of a unique situation where the harms also stem from the chilling effects that such meritless lawsuits have.
Can I ask you on that?
Yes.
So it seems like the language of the statute here is kind of strange. I mean, when it says that the claims are without merit, that's just kind of a regular thing. And then it says primarily because such person or entity has exercised the constitutional right of free speech. It seems like there's some cases that interpret this primarily because stuff is essentially just, does it arise out of free speech? But then if you read sort of the kind of the context for this, it seems like it's almost like a retaliation type thing. And I'm kind of wondering what is it that the court is supposed to be deciding at this early stage? I mean, obviously the without merit, certainly at a motion to dismiss stage, it's just going to be based on, the allegations in the complaint. The primarily because such person or entity has exercised the rights, is the court just going to look at whether the substance of the lawsuit has to do with a speech related thing, or are they going to be looking at, someone's motive for bringing it, or if it's animus or something? I mean, part of what I'm struggling with is, in order to decide whether it makes sense to have an immediate appeal, you have to kind of have a sense of what are the types of decisions that are going to be made here. So what's your take on that?
That's exactly right, Your Honor. And this is something that the committee and the subcommittee that was tasked with looking at this wrestled with, because there is debate over exactly that. What is the court, the trial court, and then the appellate court, looking at the trial court's order, supposed to determine? Is it some kind of animus? Is it some kind of intent? Or is it just lining up, the claims and seeing whether they fall within the protected activity within the statute? And those are open questions. And the committee didn't feel like it was in the position to make those determinations, other than to flag them and to propose an amendment that would not narrowly constrain review, but that would allow review to resolve these questions. And so it's propitious that while we now have this petition to amend the rules pending, there are merits cases pending before the court on the reviewability issue. And so I would submit, and the committee would submit, that to resolve these substantive issues, it perhaps makes the most sense to resolve those in the merits cases first, with the pending rules case as the vehicle to review. And this is what the court did in the Beach Community Bank versus City of Freeport case, when it amended the rules to allow review of sovereign immunity. It's 150 Southern 3rd 1111. The same day decided the rules amendment and said we're reviewing sovereign immunity, and then determined and explained in the merits cases the decision for doing that, and reviewed the merits of those cases. This court also did a similar used a similar vehicle with FHP versus Jackson, again with immunity issues, and explained its rationale for amending the rule, and then sua sponte amended the rule to allow review of the pending cases. So
what should we make of the fact that a plaintiff who is, faces a motion that this was a violation, if they prevail, they can actually get attorney's fees? I mean, that just strikes me as kind of going against the idea that this is some extraordinary, immunity related thing. I mean, it does. I mean, this is a very odd statute. So what are the attorney's fees that the plaintiff would be entitled to, just for the litigating the issue of whether it violated SLAPP, or the whole shebang?
That is also, I believe, an open question. I believe there are some perhaps federal court cases that that may have come one way or the other. And so, again, the committee didn't determine that question of what type of fees, but the committee did look at the fee provision within the context of whether or not this is going to add to the court's workload or add delay to the process through a non-final appeal. And because of that disincentive to file a bad faith anti-SLAPP motion because of the fees, the committee looked at that and said, okay, well, this isn't going to add to the delay. The statute already has safeguards in place. So that's the extent of the analysis of the fees that the committee looked at.
Can I ask a question about the number of times, the way it's written? Could someone bring a motion to dismiss, appeal that, and then later bring a motion for summary judgment and appeal that?
Yes, Your Honor.
So there could be multiple appeals. Is there any concern about the delay that would potentially cause?
So there certainly could be multiple appeals arising out of this. First, a motion to dismiss, a motion for summary judgment. There also seems to be some third. It almost seems like there's three types of motions within the statutory language, right? That motion to dismiss, motion for final judgment in favor of that party. And then this motion for summary judgment, quote, seeking a determination that the lawsuit was brought in violation. Those might be different. The committee wasn't sure, and that's why the committee is keeping it broad so that these substantive issues can be resolved. However, when it comes to delay in successive motions, we see this in the sovereign immunity context and other immunity contexts where you have motions to dismiss, denied, an appeal, and then motion for summary judgment, denied, and an appeal. So in, again, those immunity contexts, it is something that occurs. And going back to the delay, it is important to note that the statute itself doesn't have an automatic stay provision, and the committee is not suggesting there be an automatic stay provision. Stays of the litigation in the trial court remain within the discretion of the trial judge. And so if there is a bad faith motion that's filed and denied on the basis that the trial judge believes it to be bad faith, the trial judge can deny a stay of litigation pending any non-final appeals. And so I think the statute already contains some safeguards against the delay that you're suggesting, Your Honor.
Thanks. And you can have 2 minutes for rebuttal.
Thank you.
Thanks.
May it please the court, my name is Matt Canigliaro. I am with Carlton Fields, and I'm here today on behalf of the Media and Communications Law Committee. I'm going to try to make a few quick points in my few minutes with the court. First, we support amending the rule. To do that would effectuate the statutory right, and at the same time, to not amend the rule would actually diminish the statutory right. And let me try to put a bit of a pin in what right I mean. The language in the statute says that a person sued has a right to expeditious resolution of a claim the suit is in violation of the statute. So it's a statutory right to expeditious resolution of your argument that this has been brought in violation. And so obviously the legislature is limited in how much it can control of the process in the court system, but the legislature has done its best to say what it would like to see happen here. And this court's way of effectuating that right in this context would be to allow 9.130 to be to provide for interlocutory review.
I'm sympathetic to that because it does strike me that if we're going to give effect to the statute, I hear you. I guess the struggle is reconciling it with our decision in Keck. And I think what you're hearing from a number of my colleagues, and what I'd ask you to address is that third prong about whether the issues posed by any one of these motions is, wound up with factual issues about, for example, what specifically was protected speech about the underlying allegation, or what the degree of expenditure is by the parties in defending a claim. These factual issues weigh in our analysis about whether to use cert, even though we're sympathetic to the clear legislative bargain here, which is move these along quickly. What can you say to address the fact that, as your colleague has said, so many of these questions are just left open by the committee?
I'll try to address that and one of the court's earlier questions at the same time. These are things that the DCAs do. Review of an order granting or perhaps denying a motion to dismiss would be de novo. It's a legal question. And same thing on summary judgment. An order granting or denying a summary judgment is reviewed de novo. And the DCAs do these things. And I'll point to the other provision in 9.130 that deals with injunctions. We have basically an order granting, denying, or modifying, or not granting, denying, or modifying an injunction can be reviewed. In theory, you could have successive appeals in any case involving an injunction. In practice, we really don't see it, not as a problem. And here I would suggest that in the end, the simple answer is the DCAs would resolve these appeals by just looking at the record. If there were factual issues, that would preclude summary judgment. If there were factual issues, that would preclude a dismissal. But if there are not, then that relief should have been granted, and that's exactly what the DCA would review. If I could try to address quickly sort of two related thoughts. First, the pipeline cases. As was alluded to earlier, there are many. Some are in this court as tag cases. There are many in the DCAs. We would ask the court to be, first, of course, to amend, but second, in doing that, to be mindful of those cases and to consider amending in a way that would allow the amendment to apply to existing cases in the pipeline so that they can have it, what I'll say is take advantage of the amendments. That would be consistent with the statutory language about an expeditious resolution. And the third thing, we noted it in our comment, and I'll just mention it quickly here. There are two other SLAPP statutes in our statutes, one in 720 and one in 718. One concerns homeowners or property owners. The other concerns condo owners. It's the same right, slightly different damages if relief is awarded, but the same right, that expeditious resolution of the claim or the argument that the suit has been brought in violation of the statute. And we would ask the court to consider not just the statutory reference to 768, but to the other statutes as well.
What do you make of the argument that, you know, if the legislature really wants to do something about this, they should put some more meat on the bone themselves, like some of the other states have done by explicitly writing into the statute kind of, you know, burden shifting or different procedures? I mean, this really just reads like you can file a motion to dismiss, you can file a motion for summary judgment. You know, the statute itself, it's not obvious what's even supposed to be in dispute. It talks about the supplemental affidavits. I don't know what those are supposed to be going to that's over and above the merits of the, you know what I mean? Why should we be, you know, you can get a prompt resolution from the trial court. The issue of appellate review is a different, you know, kind of a separate issue. I mean, why should we be trying to address that?
I think the answer is in the phrase expeditious resolution. It's not just a determination, it's resolution. And to get resolution on these issues, if you are the movant here and your motion has been denied, is to get review. And that's what 9.130 is there for. This court is the only entity in Florida that can decide to allow that sort of review, and that's why we ask for it. Thank you.
Good morning, Mr. Chief Justice, and may it please the Court. I'm Dylan Esper, arguing against the rule change. I want to start by addressing 2 points that were made by my friends over here. Firstly, on this issue of expeditious review, it's important as a matter of statutory interpretation to note that that's in Clause 4 of the anti-SLAPP statute. And under nocitura sociis, you look at the words around that wording in Clause 4 to determine what it means. And if you look at that, that's a clause all about trial courts. It says expeditious review, and then it says the trial court is going to hear a motion to dismiss or a motion for summary judgment. It has the supplemental affidavit language that's a little bit confusing, which is also, of course, going to be filed in the trial court. It talks about the fees and damages that are going to be awarded in the trial court, and it talks about the calendar preference that's going to be awarded in the trial court. So all of those things that our expeditious review is referring to are trial court rights. It doesn't say anything about appeals. And indeed, when you think about expedition on appeal, the policy arguments are totally different, because expedition on appeal also has to take into account the fact that if litigants are going to possibly get 2 bites of the apple here, a review of a motion to dismiss and then a review of a motion for summary judgment, these cases actually might not be expedited at all. They may drag on and on. and they may be stopped twice in the middle of trial court proceedings for an appeal to take place. That's not expedition, and that's not consistent with anything in the legislative intent. The second point I wanted to make about arguments made by my friends is about this open question. I heard it referred to 3 times that the committee found certain questions to be open, including one of the basic questions under this court's Keck test, which is the issue of whether there are factual issues on these appeals. It's an open question. This court was told whether or not that language in the SLAPP statute about the filing being made primarily because of the exercise of constitutional rights refers just to the issue that there's a First Amendment issue in the pleadings, or whether it refers to the plaintiff's motive in filing. Well, that's crucial to determining whether there should be a rule change or not. On the one hand, if it is just a matter of there's a First Amendment issue in the pleadings, that might point one way under the Keck test. But on the other, and this, by the way, is the way I read the statute, that the court is supposed to inquire as to the motive of the filing and whether it was primarily, that's a word that describes motive, filed because of the exercise of constitutional rights. Primarily is important because that's a word that describes weighing. There can be multiple motives to file a suit. You wouldn't say primarily if it was just a matter of what's in the pleading. You say primarily filed because you're going to say, well, did they file it for the reason of suppressing someone's constitutional rights, or did they file it because there was some valid reason to file it? And if that's the inquiry being made, then that's factual. And there's no way to advance a rule change of this magnitude and to say that every anti-SLAPP defendant is going to get possibly 2 non-final appeals in their case without even knowing whether the issues involved are going to be factual issues regarding to the motives of the plaintiff with respect to filing the case. And I would add one more thing about that, which is if I'm right that this statute asks for a factual inquiry, that militates strongly in favor of waiting until the end of the case for the appeal, because at that point you're going to have a trial record, you're going to have testimony, you're going to have witnesses, you're going to have documents. You're going to have a lot of stuff in front of the Court of Appeal from which they can discern whether or not the case was primarily filed to suppress constitutional rights or not. Whereas if every case is going to go up on interlocutory appeal after a motion to dismiss, you're not going to have that. What you're going to have instead is you're going to have very cold records with just a complaint and some briefing on the motion to dismiss, and courts of appeals are going to be trying to determine the primary motive for the filing, and that's a purely factual issue, and that's not the type of thing that under the Keck test should be heard on an interlocutory appeal. What I want to say about the statute itself is fundamentally it doesn't create immunity. It doesn't state that it creates immunity. Statutes that create immunity clearly say so. For instance, it's in the same chapter as the SLAPP statute is 768.39 Florida statutes. That statute is entitled Immunity for Educational Institutions for Actions Relating to the COVID-19 Pandemic. As you can tell from that title, it was passed recently. This is the Florida legislature recently granting a class of defendants immunity. And it says in its operative language, quote, may not be held liable for and shall be immune from. That's what you see in a statute that grants immunity. There's no such language in the SLAPP statute. The SLAPP statute contains a lot of language condemning SLAPP suits. It says they shouldn't be filed. We don't deny that. It is very condemnatory of SLAPP suits. But the remedy that it creates for that is, as your honors have intimated, a form of fee shifting. The theory the legislature was operating under was that if you're a plaintiff and you're considering filing a SLAPP suit, you're going to look at this statute and say, this case may be quickly dismissed, and my client may have to pay the other side's attorney's fees, which could be substantial. And the plaintiff's lawyer is going to tell his or her client that, and the plaintiff's lawyer is going to say, you be careful about filing this thing if we can't allege claims that have any merit. That's the deterrent effect of this statute. It's real. And that's why the legislature can sensibly say that this statute prohibits slap suits, because what it does is it forces plaintiffs' lawyers and their clients to make that calculation. But it doesn't create immunity. And the court already mentioned that 2 federal district courts, plus the Lamb case, both said that all 3 of them said that this was a garden variety fee shifting statute. And that's the best interpretation of the statute. Indeed, 2 members of the Appellate Rules Committee, after they read our letter, flipped on this. And they said, actually, Mr. Esper's firm is right. This is, in fact, not a statute that grants immunity. And they did that because I think they took a fresh look at this statute and the arguments we made, and they said, in fact, it doesn't create immunity.
If you were going to direct us to one statute to look at as a counterpoint, one that does create an immunity or does create different evidentiary burdens as like a clear comparator to this, which one would you direct us to?
Well, I'm not sure, Your Honor, about evidentiary burdens, but in terms of immunity, I would direct you to 768.39 because it's in the same chapter. That's a great example of how even in this same chapter, when the Florida legislature wants to create immunity, they know how to do it. And they do it by express language. And that's how it should be, because the fact of the matter is saying that someone's immune from suit creates a whole bunch of consequences, including, obviously, immediate appeals that, as Your Honors had intimated, flip the normal burden in a case. Normally, your due process rights as a defendant is you got to take a shot with the trial judge and say this claim isn't pleaded properly, it has no merit. And if the trial judge disagrees with you and you have to then expend money on litigation, that's generally not considered an irreparable harm. It doesn't get you certiorari review. And that's the normal rule in litigation. That's the normal rule in litigation, not only in the courts of Florida, but all over the country.
Well, I mean, and plus, I mean, the whole concept of, I mean, you're immune from a meritless suit. I mean, that doesn't even make any sense. I mean, it just seems like they basically, especially when it's the government who's doing it, the legislature wants to penalize someone who brought something that wasn't just meritless, but also maybe was brought with some kind of improper motive or something. But just as a concept, the immunity thing just doesn't even really seem to fit.
I completely agree, Chief Justice Munoz. In fact, another reason why this statute can't create immunity is because immunity is normally class-based. So prosecutorial immunity. How do we determine if someone gets an immediate appeal? Well, we ask, are they a prosecutor? And if the answer is yes, they get to appeal. It's simple. Are you a government employee that can claim an immunity defense? Yes? Okay. Obviously, on my statute that I cited earlier, are you a school facing a claim regarding COVID relief? Yes? Okay. Immunity. But under this statute, any defendant can claim immunity. Any defendant can style their claim, their motion to dismiss, as an anti-SLAPP motion. What stops them? Certainly any case that involves any spoken or written words, the defendants can argue those words are protected by the First Amendment. Therefore, it's an anti-SLAPP motion. Therefore, I should get immediate appeal because I'm entitled to that immunity determination to be immediately determined by the Court of Appeal. I shouldn't have to wait. Immunity can't work with this statute. It doesn't make any sense. I do want to address this issue of the Keck factors because the other side brought up the Keck factors. The Keck factors, yes, it is true, this statute does involve First Amendment rights. I do not in any way mean to devalue that. But there's 2 other things that this Court should consider in that first prong of the Keck analysis. First of all, the fact that it doesn't create immunity. I think I've shown that in a number of ways. And secondly, that the rights of plaintiffs are also important. And remember, what's going to happen when you go up on interlocutory appeals, you're going to already have a ruling from a trial judge that whatever the speech is that is claimed is unprotected speech. So you're dealing with the right of plaintiffs to file cases alleging that unprotected speech has harmed them. Right now in another state, there's a case involving the Dominion people and Fox News, and they're suing Fox News for alleged defamation. And they just beat back a summary judgment attempt, and the whole point of their argument is they're saying this was unprotected speech. This was not speech that was protected by the First Amendment. These were just lies about dominion. And based on that, they've won a ruling, an interlocutory ruling from the court over there. And the question is that don't the plaintiffs have rights and interests in that situation too, in bringing the case forward and making sure witnesses and evidence don't get lost, and not having their costs brought up with an appeal that could be completely meritless? Those interests count in the nature of the right too. The second issue under Keck is the likelihood of recurrence. First Amendment claims, unlike immunity claims involving sovereign immunity or prosecutors or whatever, these cases come with all sorts of different facts. There are millions of different fact patterns that raise First Amendment issues. There are different causes of action. One case might be a defamation case. Another case might be an invasion of privacy case. There may be different legal tests involved. So the likelihood that the Court of Appeal can just take one of these cases and announce a rule that will apply to the class is very low. The third issue, resolution of factual issues, I think I've covered that. This statute calls for a determination as to what the intent was at the filing. That's a huge factual issue. That's the type of issue you want to have resolved at the end of the case. And finally, the fourth part of the Keck test, the increased workload. Every case that involves a written or spoken word, there's at least the possibility that some defendant is going to style their motion to dismiss or motion for summary judgment as a slap motion, and they're going to demand an immediate appeal. And indeed, if they're granted an immediate appeal under this rule change, that's going to encourage defendants to do that. And as a result, there's going to be a massive increase in workload for the appellate courts. So I don't think this works under the Keck test. I wanted to make one more observation about something my friend on the other side said, and that was analogizing this to injunction cases. This is not like injunctions, because appeals after injunctions involve a situation where there really is a right that everyone agrees about that's lost. If you win a case at the end of the case that establishes you had the right to do whatever it was you were doing, but all this time you were enjoined from doing it, that's an irreparable injury, that your damages don't solve that. So the whole point of taking up an injunction early is that it's restricting a litigant's freedom as an interim measure, and we go up on appeal and we decide that. That's, again, totally different than this. The injury that defendants are facing in these cases is just the injury of an ordinary litigant facing the ordinary costs of litigation because they were unable to prove to a trial judge that they were entitled to relief. The only workable approach to this statute, the only fair approach, is the one that's consistent with both what the legislature did do and what it didn't. It's to provide defendants with exactly what the legislature gave them: expedited dismissal and fee shifting at the trial court, rather than an immunity that the legislature never granted them. We urge rejection of the proposed amendment.
Just a few brief points, if I may. I'd like to point out that the Fourth District's articulation of the harm that the statute is designed to avoid. So the Fourth District, in Materio, in which it said we're not going to use cert, but we think these are important rights, said the harm the statute seeks to prevent is the filing of the lawsuit for the purpose of suppressing the exercise of First Amendment rights. The longer such suits linger, the greater the expense and interruption of the lives of their targets, the greater the threat of financial liability, the greater the chill on the exercise of the constitutional rights. Forcing defendants to wait till the end of a factual inquiry at the end of the case renders those protections illusory because they have been chilled the entire duration of the litigation. And that is really the thrust of why the committee thinks that the rule amendment should be accepted. So the committee respectfully requests that the court would amend 9.130 to include review of these types of orders. Thank you very much.
Thank you.